Hello, my name is Michael Tessaro and I prepared this presentation entitled Chicken Fees for NAB Nabbing. Admit that's a pretty bad pun, but I guess what it's related to is a case against NAB where the court found that they'd engaged in unconscionable conduct and they were only fined a very small amount. And it was in relation to the charging of periodic payment fees. So that's the pun on chicken fees for NAB nabbing. And I guess the "oh come on" expression there is about the size of the penalty, which the judge himself accepted wasn't going to achieve any specific or probably general deterrence. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my practice of Tessaro Legal Consulting for the last 16 years. And I help companies, individuals with competition and consumer law matters. Also do some expert consultancy work for some legal publishers. And prior to that, I worked at ACCC for about 15 years, and I had a variety of roles, including in enforcement and mergers. Now, the outline to the presentation is pretty simple. I'll look at the initial liability decision, which was back in 2022, and then the penalty decision in late 2023. And I decided to wait until the penalty decision came out to do the presentation. Now, the case involved the charging by NAB of periodic payment fees of customers, and this was after it discovered that it no longer had a contractual entitlement to charge the fees. So effectively, a number of customers were exempt from paying periodic payment fees, but the systems within NAB weren't adequate to prevent that from occurring. And the key issue here is that once they discovered the problem, they didn't seek to stop charging these fees. They continued to charge the fees, and that's where the unconscionable conduct arose. So the judge concluded there was a breach of Section 12CB1 of the ASIC Act, and that NAB had engaged in unconscionable conduct. There's also some instances of them charging higher fees than they should have. Now, over the relevant period, which was quite a lengthy period of time, NAB charged the wrong periodic payment fee on almost 75,000 occasions. So that sounds quite serious, but when you look at the total amount of money that people were overcharged, it's only $139,000. So it's one of these types of conduct that has a lot of separate instances of conduct, but the total detriment to consumers is quite low. And as you can see there, NAB remediated the losses incurred by customers, and as at the date of the evidence in the liability judgment, they'd remediated almost all of the customers. There are only about 72 customers who hadn't been remediated yet. So the first case ASIC ran was a misrepresentation case, and the judge rejected that case. And he put this argument that effectively telling customers that they're going to be either paying a particular periodic payment fee or that they're going to be exempt from the particular fee is incapable of conveying a representation. So he effectively said there was no misrepresentation case because it can't be that just telling the customer about these periodic payment fees is a representation. So as you can see in the second paragraph there, he didn't believe that that could amount to representation. So the case was rejected. He concluded that it was too vague and too remote from the practicalities of delivery of statements of account to give guaranteed verification of what the narration said. So when somebody gets a bank statement that says something about periodic payments, that isn't a representation for the purpose of the Act. I'm not too sure that's actually correct, but anyway, that's what he decided. Then the unconscionable conduct case, and this is where most of the activity occurred. The first thing he did was quote Beach's decision in ASIC and AGM markets, where Beach set out this very helpful shopping list of factors to consider when looking at unconscionable conduct under the ASIC Act. And I'll go through them, I think quite worthwhile. Firstly, the boundaries of statutory unconscionable conduct are not limited by equitable doctrines, so it's got maybe a broader application than equitable doctrines. Clearly, the legislation 12CB states that you have to consider the conduct in all the circumstances, so that necessitates a close consideration of all the facts that might be relevant to finding unconscionable conduct. You can't take an atomistic approach. Also, the values that are explicitly or implicitly enshrined in the text, context, and purpose of the relevant legislation has to be considered, and that also includes societal or community values. So that's what you're looking at. You're judging the conduct against community values. The legislation, both in the ASIC Act as well as the Australian Consumer Law provisions, are intended to set up a new normative standard which conduct is to be measured against. The concept of moral obloquy is not something that a lot of weight should be put on. In some early decisions, it was said that there had to be an element of moral obloquy for unconscionable conduct to be established. That has been pretty well rejected by the High Court in the Stubbings case. Also, the various values that underpin the sections, such as fairness and equality, asymmetry of bargaining power and information, lack of understanding or ignorance, also good faith and fair dealing. They're all relevant considerations that should be weighed up. So all these issues are relevant. However, if you uncover unfair conduct or exploitation of vulnerability or unjustifiable self-interest or hardship, those factors alone are not sufficient to establish unconscionable conduct. So it's a case of looking at all the relevant factors and not putting inordinate weight, as some of the cases have done, on particular ideas, particularly the vulnerability of a particular person. Also, you have to look at the, or if you do look at the actual state of mind of the alleged contravenor, that'll be relevant. But again, not to make that the sole focus of your inquiry. Again, industry practice is relevant, but again, should not place too much weight on it. And the boundaries and content of any applicable statutory regime beyond that of the ASIC Act and the Corporations Act is an important contextual matter. So this is looking at other statutory regimes. I guess the one that jumps out the most is obviously Australian consumer law. The types of decisions that have been made in relation to that legislation are not relevant to establishing statutory unconscionability under the ASIC Act. Also, it is not necessary to show that somebody was under disadvantage, and this goes back to the sort of Amadio idea of a special disadvantage. That isn't necessary. And also inequality of bargaining power, again, it's a factor that's relevant, but not to put too much weight on it. So I guess it's sort of saying don't take a prescriptive approach and trying to find specific elements established. Really, it's a case of weighing up a range of different factors, comparing all those factors to community standards and determining whether conduct is unconscionable. And there was a couple other things that he included in his list. It's quite a long list, isn't it? It said it's inappropriate to focus on one or more of the matters to the exclusion or unjustifiable expense of others. So that's, I guess, reinforcing what I just said. Don't put too much weight on a particular factor. Look at all the different factors. And clearly, it's got to be a significant departure for community standards because these provisions introduce significant pecuniary penalties. So that's it's a requirement to characterise conduct as being a serious or significant departure from community standards. So the other case that he looked at is this Allsop case, which is very, very similar, really, ASIC and ANZ. And here he looked at a similar thing where amounts are being charged after the bank became aware of their lack of entitlement to charge certain amounts. And he makes the observation that, in Australia, there's a reliance by customers on the integrity and good faith of their banks. And that's really important. It's not just it's an important value for the social and commercial life of the country. It's that element of trust between depositors and borrowers and their banks is at the heart of the economic system. It's founded on trust and good faith in a commercial sense. So it's a very high standard that is expected of banks. And then he goes, it would shock any consumer to know that their bank was continuing to take their money when they knew they had no authority to take the money. So he concluded that where a bank continues to take money from a customer when they know they have no legal entitlement to it is a pretty clear example of unconscionable conduct. And as you can see, probably the understatement of the year, the customer might well consider that he or she had not been treated fairly and in good faith in those circumstances. It's bordering on fraud when you think about it, to take money from people knowing that they don't actually owe it to you. So looking at the particular case, he concluded that it was a very similar situation to ANZ. By January 2017, NAB was aware that it did not have a right to take this money from their customers, and it continued to levy these periodic payment fees from their customers. And I guess he refers back to the Allsop judgment just referred to. Customers who were wrongly charged would at least be surprised that a bank would do so. I think that's again an understatement. So they initially weren't too sure what was going on in NAB, but then they investigated and they discovered that they were wrongly charging people, and they didn't tell the people that they were wrongly charging you. They sort of hid the fact, and secondly, they continued to charge these people money that the bank wasn't entitled to. So the judge concluded that the NAB had promoted its own interests, I guess reputational interests, because it clearly wasn't about money, promoted its own reputational interests above those of the consumers, and that's considered to be highly unconscionable conduct. Then they looked at basically the community expectations that people have of banks, and clearly a bank seeking to overcharge customers in circumstances where it knows it's not entitled to the money is a serious departure from community standards. And then he says something that I think is somewhat surprising, and I think might suggest that he might be a little bit out of touch with views in the market. He says, in an Australian context, banks are generally regarded as honest and ethical participants in the financial service industry. So I'm not too sure whether that's the general community health standard. We did have a Royal Commission that uncovered a lot of bad behaviour, and there've been a string of cases against banks, charging dead people, charging people who were not owed money, a lot of negative conduct. So I'm not too sure whether the banks are generally regarded as honest and ethical participants in the market. Now, he concludes that the conduct of NAB fell so far below the standards required of the bank's obligations that it was unconscionable, it was neither proper nor right according to ordinary commercial values in Australian society, and it was offensive to conscience. So he concluded the conduct was clearly unconscionable. They also ran an efficiently, honestly and fairly breach under Section 219A of the ASIC Act, or the Corporations Act, and here the issue was whether they effectively breached one of their licence conditions. And it's interesting that as a standalone breach of this particular obligation, the court decided that they hadn't breached it, but the unconscionable conduct without more indicated that they had actually breached its obligation of acting honestly and fairly. So as you can see there, it was neither competent nor ethical for NAB to continue to charge their customers and to fail to inform them or advise them that they were being charged. So then we go to the penalty, and there's a pretty big delay between the liability judgment and the penalty, which I don't quite understand why it took so long. But here the question was whether ASIC had pleaded one single contravention of the relevant legislation of the ASIC Act in relation to unconscionable conduct, and if they had, whether the penalty was limited to the maximum at the time, which is 2.1 million, or rather whether ASIC had actually left the door open to there being multiple contraventions. And as you could probably remember, there were 75,000 instances of NAB wrongly charging customers. And the judge concluded that he was limited to the one contravention based on the pleadings and the way the case had been run, so he imposed that penalty. Now, looking at this particular decision, it's interesting. He says 2.1 million is the most you can impose. Then he says, unfortunately, this penalty of 2.1 million is wholly inadequate when viewed against the nature of NAB's conduct, especially the fact that it disregarded customers' rights over an extended period. This is also a context where NAB is a repeat offender against the financial service legislation, and it appears to place a very low priority on respecting the legal rights of customers. and he believed that a penalty several times the statutory maximum would have been more appropriate. So he's sort of saying this penalty is not going to achieve any specific or general deterrence, but he's got no option. And that's the point that I think controversial. He clearly did have an option. He could have easily imposed a bigger penalty, but he chose not to. Now, looking at this, he's talked about the written submissions by ASIC, and they've sort of argued that it is multiple contraventions, and if you extrapolate the number of contraventions out by the maximum fine, that would be a maximum fine of $130 billion. But clearly a fine of that nature is not used as a proper yardstick. What the courts tend to do is disregard these enormously big penalties and try to arrive at a lower penalty that actually will achieve specific and general deterrence, but is more realistic. Now, he said here that the regulator's case has to have some rigidity to it. You can't be in a situation where the regulator argues a particular case, pleads a particular case, and then they're allowed to, as I say there, stray beyond those boundaries without good reason. So he said, in the way he says things is a bit curious. Likewise, the court may be less inclined to permit a regulator to treat those terms as plastic or open textured, so as to allow a case that has not been disclosed openly from the outset to be raised belatedly in a manner prejudicial to the alleged contravener. So he's saying, I can't let ASIC depart from the cases pleaded and argued, because that'd be prejudicial to NAB. And then he says that here that the language used by ASIC was very suggestive of there being one contravention. So he looked at the words used in their pleadings, and they said that they continued or continuing to engage in a breach and failing to do various things, and these indicated that there was a single breach being alleged by ASIC. So he's taking a very technical approach to the issue. And then he said, it is with respect beyond reasonable argument that the unconscionable conduct case advanced by ASIC at the liability stage of the proceeding was, in broad terms, to the effect that NAB's continuous course of wrongdoing over a period of time during which it was aware of certain matters was worthy of admonition. Well, that's obvious. Try as one might, it is impossible to detect a clear and distinct case that NAB engaged in unconscionable conduct on each occasion that it wrongly charged PP fees. So he's saying, the whole case has been run on one basis. You can't turn around now and say that it was done on, it was argued on multiple contravention basis. Now, he also observes that if ASIC had been claiming that each particular occasion that NAB had wrongly charged the customer was a separate breach, there would have been some effort dedicated to the task of identifying the total number of contraventions. So he said, because ASIC didn't really do that, that suggests that they weren't arguing for a multiple contravention case. It seemed pretty clear on the evidence that there was a distinct number of contraventions, so it seems to me that they did establish that. And then he says it's not appropriate for the court to allow at the penalty stage a regulator to turn around and go from a single contravention to multiple contraventions, because that would create prejudice, and it's obvious. Well, I'm not too sure it is obvious at the end of the day. The question is, what would NAB have done differently if it thought it was facing multiple contraventions? And here's the important decision by Mashinsky, where he looked at a similar issue where Meriton had been sued by the ACCC, and they had argued it a particular way and pleaded a certain way, and he thought that he had the power, Mashinsky, to allow the ACCC to, I guess, change their position to argue there were multiple breaches. So as you can see, Mashinsky concluded that it was open to the court at the penalty stage, open to the ACCC at the penalty stage to seek to establish a larger number of contraventions. And the reason he decided that was there was reason to believe that even if ACCC had done it earlier, Meriton would not have run its case any differently. I think that's a key thing. Would NAB have run their case any differently? Clearly, the Mashinsky and Meriton didn't think that they would run the case any differently, so he allowed it to happen. And so this is a fundamental point. Darrington could have allowed ASIC to argue for multiple contraventions, but he chose not to. Now, here he talks in very emotive language, where regulators belatedly attempted to increase the number of contraventions. There is, according to little reason, subjected to intense scrutiny of the respondent's contention that it would have run its case differently. He says, you shouldn't descend into the minutiae in order to critically examine the possibilities. It's an undue exercise of speculation, apt to subvert the procedural fairness to which the respondent is properly entitled, and it should be avoided. So he's saying, let's just assume that this would have caused them prejudice. Let's not descend into the detail of how they would run the case differently. I think that's precisely what you need to do. You need to see if they would have run the case any differently, and if they wouldn't have, you should allow the regulator to broaden the case. Here he goes on, he talks about the policy. He says that the general principles set out above in the civil penalty context, the regulator is on a duty to articulate its case clearly and to prosecute the case sensitively and diligently. He says that duty would be undermined if it was accepted that a regulator could just escalate its case at the 11th hour and cast the respondent the onus of proving that such an escalation would, if signalled earlier, have caused it to change its strategy in defence. So he says not to get into the minutiae of the way NAB would run its case, but then he seems to do it, which is also somewhat contradictory. He said, ambush of this nature has long been discouraged, and there is all the more reason to stress the court's disapproval of such tactics in a civil penalty context. I don't quite understand that either. So here he says that allowing ASIC to broaden its case out to multiple contraventions would undermine public confidence in the legal system, diminish that public confidence. He said the unfairness in this scenario is striking. The potential harm to public confidence would doubtlessly be magnified if the court accedes to a change in a course that is not supported by adequate explanation or justification. Well, clearly the public interest issue that he's missing is the fact that a penalty 2.1 million won't achieve specific general deterrence, and so a company's engaged in a very serious breach of the unconscionable conduct provisions, and the penalty will achieve no outcome, no positive outcome in terms of deterrence. So that seems like a pretty good explanation for why the court should look at allowing ASIC to argue for more contraventions, and also, I guess, the prejudice. It's really not clear that NAB suffered prejudice here. What would they have done differently to the way they ran their case? And I think he just assumes that they suffered prejudice without actually exploring that issue. Here he says, it takes a moment's thought to reveal that a party facing a penalty of 2.1 million would run the case much differently if they thought they were facing a $130 billion penalty. Again, that's somewhat disingenuous, because I think we all know that the courts tend to the courts do disregard those enormously big penalties as being quite unhelpful, and they would have been looking at a bigger penalty. And there's no doubt that that NAB threw everything at this case that it could. Would it have changed its strategy if it thought it was running a much more expensive case? I don't think so. I think they would have run exactly the same case. And then he says it's unnecessary to speculate further as to what consequences these steps or others might have had in the ultimate outcome. The prejudice to NAB is sufficiently clear. Well, I don't think it is. Like, he's assuming the prejudice. See, before he says, I'm not going to delve into the minutiae, then he goes into it a bit, but then he says we don't really need to go into it too much, because anybody can see that the prejudice to NAB is significant, but that doesn't go without saying at all. So here he says that he describes the conduct of NAB, and this just shows how bad the conduct was in the judge's mind. They unjustifiably advanced their own self-interest. They deliberately and cynically took advantage of customers' unawareness. They were prepared to allow the overcharging to continue. And he says moral dereliction, inherent sense of entitlement, that we can charge these people whatever we want, we don't have to tell them. It is also perhaps a product of a corporate culture that places low priority on observance of the law and on respect for customers' legal rights. So this is very bad conduct in the judge's mind. It's intentionally engaged in unconscionable conduct, and he doesn't think that there's a public interest in allowing ASIC to argue for a bigger penalty to achieve some specific general deterrence. So I think he's got this all the way backwards, actually. I think he could have opened this case up and imposed a much bigger penalty, and I don't think anybody would have thought he was doing something inappropriate. I actually think the decision arrived at undermines public confidence in the penalty regime more than would have occurred that if he'd allowed ASIC to argue more contraventions and imposed a bigger fine. So here he says again, and this is making the point, regrettably, he doesn't believe he can impose more than 2.1 million, which I think that's wrong. And then he said the maximum penalty of 2.1 million is unlikely to have any real impact on the bank's future conduct. So he's posing a penalty that is going to have no specific deterrent effect on NAB. Now, that is in the public interest. The public interest is to achieve both specific and general deterrence, and this judgment and this penalty doesn't achieve that. So just summarising there, it's a disappointing judgment. I puzzle when I read a lot of Derrington's judgments because it just seems somewhat contradictory. In one moment he's saying let's not descend into the reasons, then he descends into the reasons, and then he says let's just, there's no point concluding that there's prejudice here. He just makes that assumption, but it's not at all clear that there was prejudice to NAB. So I guess the unconscionable conduct arose from continuing to charge customers where there was no legal entitlement and not telling them of the problems. So based on the ANZ case where the Chief Justice spoke about this type of conduct is clearly unconscionable. I think these cases also show that despite the banks making a lot of money in their operations, they're really not investing enough on their IT systems. Here there was a legacy IT system, was very old, and the other thing you find is that they have problems with these old systems, and then when they identify the problem, well, it takes a long time to identify what the problem is, but then it takes even longer to work out a fix. And this shows just how bureaucratic some of these banks are, that it's not somebody can just immediately make a decision. It has to go through all these different channels, has to be approved, there has to be budget, and as a consequence they continue breaking the law for a lot longer because they can't move rapidly. So this is a problem. A lot of these cases against banks taken by ASIC show this recurring problem with legacy IT systems. Everybody agrees this isn't going to achieve any deterrence whatsoever. It's not going to achieve any specific deterrence, no general deterrence. It's a penalty that really is going to achieve nothing at all, and I think it does undermine public confidence in the civil penalty regime. I think it's fair to say ASIC pleaded the case as one continued contravention, but that's not the issue. Okay, maybe they should have pleaded it as multiple contraventions, and I guess they'll know next time to do that. But clearly it was open to the court, as shown by Mashinsky in the Meriton case, to allow them to change the case, and that required the judge to consider whether NAB was going to suffer any detriment, was going to be suffer any prejudice, and would they run their case any differently. And I think if he'd really looked at that issue properly, he would have concluded they didn't suffer any prejudice and they wouldn't run the case any differently. Maybe they would have an extra barrister in there, but they don't cut corners, the banks, in terms of the legal resources they throw at these cases. And as I said a number of times now, Derrington could easily have allowed ASIC to broaden its case to, at the penalty stage, to allow the consideration of multiple offences, multiple contraventions, and could have imposed a much bigger fine. Having said that, most of the fines in this area haven't really been big enough to deter the big banks, but at least you would have had maybe a zero after it, maybe 20 million or 50 million or something like that. But 2.1 million for intentional, unconscionable conduct affecting quite a number of consumers that went on for quite a long period of time is just not good enough. And I think Derrington, I'm not too sure if there's an appeal, probably not an appeal on this particular case, but I think Derrington didn't really want to allow ASIC to do it and found lots of reasons to prevent them from doing so. So that's all I had. Hopefully you found that interesting and helpful. It's an interesting case. I think Beach has list of factors to consider when you're looking at unconscionable conduct under the ASIC Act is quite helpful. I think Derrington's judgment's very disappointing. I guess if you have any questions about this particular presentation, feel free to give me a call or drop me an email. Bye-bye.